will be our moderator tonight.
Thank you very much. This is a very strong argument against deregulation. Ladies and gentlemen, 200 years ago today, 39 men signed a document known as the Constitution of the United States. In those 200 years that have followed, that document has been amended 26 times. Those 26 amendments deal with a list of critical issues, including the rights of women to vote. They do not include, however, the rights of an amendment dealing with the rights of women to equality. Those 26 amendments, by the way, were drafted, debated, and decided by a system dominated by males. And today, on this 200th anniversary of this document we call Constitution, the Senate and the nation are engaged in a great debate involving the nomination of a man to serve on the Supreme Court and to interpret this important set of fundamental principles. This great debate, one that involves the approach jurists ought to take in interpreting the Constitution, gives evidence that though this document is 10 score years, it remains alive, vigorous, and meaningful to a free people. Tonight, on the anniversary of this historic event in U.S. and world political and legal history, we are honored by the presence of two distinguished commentators on the Constitution. That both are women is not coincidental. It is, however, most appropriate. They will bring us insights and observations about our topic that those of us who are male are unable to provide. It is self-evident that our speakers on women and the Constitution should indeed be women. It is somewhat less evident why a male has been asked to introduce them. Before I turn to our speakers, permit me a few moments of background on their subjects. They have been asked to deal with two subtopics, one involving equal protection, gender, age, and economic status. And in that discussion, you may hear references to such cases as Griswold versus Connecticut, where the Supreme Court established a fundamental right to use contraceptives in the privacy of one's home, a right that many, including Judge Bork, may question. A case such as Roe versus Wade, where the right of women to choose an abortion was announced by the court. And Bowers versus Hardwick, a 5-4 decision of the United States Supreme Court that refused to expand the concept of privacy to include consensual homosexual conduct. Our other subtopic is due process, privacy, and personal autonomy. And when our speaker addresses that subject, you may hear references to such cases as Frontiero versus Richardson, where the court laid the groundwork for the heightened level of scrutiny that is applied to classifications based on gender, and San Antonio versus Rodriguez, where the court refused to strike down classifications based on wealth, and Massachusetts versus Murgia, the police officer retirement case, where it was held that classifications based on age are not suspect. What do all these cases mean to us? These cases demonstrate that the Supreme Court has a major policy-making role in our government, far more important than its role 200 years ago. Therefore, I suggest to you it is imperative that we select the right justices to fill vacancies. All justices must be extremely intelligent and ethical. That much is self-evident. But while those qualities are necessary, they are, I suggest, not sufficient. As we approach the 21st century, we must look at the judge's judicial and political philosophy. What that philosophy should be, however, is the subject of great controversy. There are those of us that think justices should have an 18th century worldview because the great principles of justice have simply not changed in the passage of 200 years. There are others, however, who have noticed that 18th century principles have to be interpreted in light of changing conditions. They have to be interpreted in light of a more pluralistic society. They have to be, to put it bluntly, our notions of equality today are more egalitarian, and I suggest to you more important than they were 200 years ago. Although we cannot fault the framers for not realizing, as most of us do, that women have been unjustly subordinated and exploited throughout history, the university community has the responsibility of pointing out the shortcomings of that limited worldview. Fortunately, the framers have provided us with a document, a constitution that is capable of growth. By that I mean our Constitution is receptive to the social movement towards real and meaningful equality, regardless of race, religion, or gender. The demand for equality among the sexes has never been fully satisfied. Furthermore, and just as important, we must be ever on guard against premature satisfaction with the status quo. In this area, among others, we have to carefully study the positions taken by persons seeking office in all branches of government, including those judges who seek our highest offices. It may be that among two otherwise equally qualified candidates, the United States Senate should confirm only those nominees who believe that our Constitution, properly interpreted, requires affirmative remedial action for women who are being unjustly treated in many walks of life. The program tonight should be lively, provocative, and educational. We will be delighted to entertain questions for our guests at the conclusion of it. Let me now introduce those guests, if I may. I'd like first to introduce Anne Frank Lewis, the former political director of the Democratic National Committee, the former national director for the Americans for Democratic Action, and a consultant to the Democratic Party and its candidates. And Ms. Lewis is going to address us on the cases on due process, privacy, and personal autonomy. Ms. Lewis.
Thank you. We should say first that it's so perfectly appropriate that a man was asked to introduce us, because we don't want to displace men entirely from the seats of power. We just want to share. Right. And we think this table is the way it ought to look, perhaps mixed up a little more. What I want to talk about, going beyond cases for a moment, is to pick up on what we are witnessing today. It seems to me we are in the midst of a historical act, and that we can step back. We have the luxury of talking about what is actually happening today in the United States Senate, and then how that applies to some of the cases we care about. For the last 3 days, I've been sitting in the caucus room of the Russell Building of the United States Senate. Now, you're probably familiar with the caucus room, whether or not you know it by name, because it has been the site of a number of major national events, most recently the Iran-Contra hearings. The room is set up now, much as you saw it then. The senators, just 14 on the committee this time, sit at a table in the front, facing the room. The table is covered with a kind of green felt, only, I think, used for Senate hearing rooms and billiard tables. Behind them, against this wall, are a row of chairs for the staff, who divide their time between listening intently and running back and forth with copies of papers and messengers. For an issue of this substance, you will find that regular members of the staff have been joined by certain law school professors, and you can tell because they just look a little older, a little more solid, but they too are now part of the Judiciary Committee staff. Behind the door, into which the staff and occasionally the senators disappear, is a committee room that would be about there, into which access is guarded by the Capitol Hill Police. And beyond that room are other staff rooms and the Senate offices themselves, producing reams of material, monitoring the hearings on television as they compare statements and questions with a voluminous record. Now, in the front row, facing the senators, sits the testifying witness. He, too, is at a table covered with the same green felt. While Judge Bork is testifying on his own behalf, the row directly behind him is filled by his family, and then a row of official and semi-official participants, and we can notice in this one Tom Korologos, who is a lobbyist who is stage managing for the White House. Now, beyond those 3 rows of chairs sit the press, and there are so many reporters at these hearings that they sit at tables which are at right angles to the rest of the room. There are 6 long tables at right angles with chairs on either side, marked with the names of the newspaper or the television station or the radio station. They take up more than half the floor space. They're writing, they're talking into microphones, and then beyond them are cameras that are going constantly. Now beyond the press, again now facing the table, are rows for the public. Some are permanently reserved for senators, their families, and guests. And the rest are filled by a rotating group of observers whose attire ranges from tourists in casual clothes to young lawyers in power ties. And then against the wall stand the permanent observers, those of us who have been working on the nomination, working with grassroots lobbyists at home or legal associations here, people who have been preparing, as Kathy has, as I have, working on this event for the last 2 months. We have a little trade-off going with the staff. We get to stay all day, but we have to stand. The people who come in as members of the public get to sit, but then they get rotated out. If your feet hold up, you can last in this business. Now, I talk about this because when we step back and think about 200 years ago and the anniversary celebrate, and we think about the Constitution, which was written, as we've heard, it was written by 55 men in a closed room in a hot summer where the windows were shut so no sound could get through. No official recorder was appointed, so the interplay which produced the document would be muted. Public attention would have to focus on the consensus, not the disagreements along the way. There are several hundred people in the Senate caucus room these days, sitting, standing, rushing around, writing for themselves and for the general public, broadcasting the proceedings as they occur, and monitoring them for today's comments and tomorrow's questions. The Constitution was written by a small, relatively homogeneous group of white men, close to one another in age, in experience, in education and economic outlook. The people in the Senate caucus room represent both genders and every race. They differ in experience and education. They differ as well in their values and their expectations for government. But about one point, there is widespread agreement. The choice of the next justice on the United States Supreme Court, who will be given the authority in our name to interpret the Constitution, that choice is the business of every American. We are entitled to know what is going on, to have our questions asked, our concerns raised, our senators contacted. Now, I say widespread agreement, not unanimity, because there were in the days immediately following the nomination of Robert Bork efforts to minimize the role of the Senate in this process. It was said in some high quarters that the role of the Senate was to confirm the president's appointees, unless the nominee had been convicted of something on the order of bank robbery, or, if not convicted, the Senate had personally witnessed him in the act. Short of that, their job was to say, yes, sir. And of course, if the Senate had so little choice in the matter, the public would have even less. A senator whose own choices were so circumscribed could hardly be expected to consider the views of his or her constituents. Fortunately, and not surprisingly, that point of view has now been rejected. A bipartisan majority of the Senate Judiciary Committee stated at the beginning of the hearings that they expected the Senate to exercise its full authority and responsibility. Perhaps not coincidentally, every poll of public opinion taken since the nomination was announced has shown that the American people expect their senators to take their responsibilities seriously and to take the views of their constituents into account. Among the fundamental assumptions of the American public today, then, there is one that no political body can afford to overlook: the expectation that people are entitled to make decisions of great import for themselves, that they want a say in the choice of those whose ideas and values will determine the course of our own daily lives. We start with privacy. Judge Bork has stated, as recently as Tuesday, September 15th of this week, that he finds no right to privacy in the Constitution. Regretfully, he points out that as a scholar and theorist, he believes such a right would have to be embedded in the text of the Constitution, and it is not there. There are other rights, not specifically mentioned, which he considers legitimate, such as the right to travel. But there is no way he can justify a constitutional right to privacy, which so many Americans take for granted. I am, I must admit, personally fascinated by this difference between the right to travel, which I am reassured to know I still have, especially tonight, and the right to privacy, which I may be losing. As I understand the Bork position, a married couple planning their vacation could comfortably set out in their car or recreational vehicle to travel throughout the country, secure in their constitutional freedom of mobility. But if they cross any state lines, before they go to bed that night, they should be prepared to check the relevant legislative statutes to see just whether and how they can sleep together. For those who think I am exaggerating, let me read you the exact language of Robert Bork discussing Griswold versus Connecticut, that Supreme Court decision which held that the right to privacy prevented the state from interfering with the marital relationship. Quote, Griswold is an unprincipled decision. Compare the facts in Griswold with a hypothetical suit by an electric utility company to void a smoke pollution ordinance as unconstitutional. The cases are identical. In Griswold, a husband and wife assert that they wish to have sexual relations without fear of unwanted children. The law impairs their sexual gratification. The state can assert, and at one stage in that litigation did assert, that the majority finds the use of contraceptives immoral. Knowledge that it takes place and that the Senate makes no effort to inhibit it causes the majority anguish, impairs their gratifications. The electric company asserts that it wishes to produce electricity at low cost in order to reach a wide market and make profits. Its customer asserts that he wants a lower cost so that prices can be held low. The smoke pollution regulation impairs his and the stockholders' economic gratification. The state can assert not only that the majority prefer clean air to lower prices, but also that the absence of the regulation impairs the majority's physical and aesthetic gratifications. Neither case is covered specifically or by obvious implication in the Constitution. Unless we can distinguish forms of gratification, the only course for a principled court is to let the majority have its way in both cases. It is clear that the court cannot make the necessary distinction. Why is sexual gratification more worthy than moral gratification? Why is sexual gratification nobler than economic gratification? For those of you who have been listening to discussion of the Indiana Law Review article over the last 3 days, this is a quote from the famous Indiana Law Review, which may be one reason why people keep referring to it. Now, if you do not believe in a right to privacy, you will disagree with every Supreme Court decision that is based on such a right. And Robert Bork has been consistent in his opposition. He has criticized Roe versus Wade, which is the cornerstone of safe and legal abortions in this country. And he said, and now again I'm quoting, I am convinced, as I think most legal scholars are, that Roe v. Wade is in itself an unconstitutional decision, a serious and wholly unjustifiable judicial usurpation of state legislative authority. I also think that Roe v. Wade is by no means the only example of such unconstitutional behavior by the Supreme Court. And then again, in upholding the policy of the United States Navy to discharge without any further reason all gay men, Bork said, quote, the penumbra considered to be the source of the right to privacy was no more than a perception that it is sometimes guaranteed by the Constitution in order to protect an activity that is. The right has no life of its own, as a right independent of its relationship to a First Amendment freedom. End quote. Now, not surprisingly, this sweeping attack on a right to privacy, which so many of us take for granted, was sharply questioned by members of the committee. And again, not surprisingly, the nominee tried to soften his record, saying he did not agree with the statute in Griswold, but just did not think the reasoning in that decision was proper. However, it was then pointed out that after more than 25 years of teaching, writing, practicing, and judging the law, Judge Bork never has found a justification for the right of privacy, or, to put it simply, the right of married couples to shut the government out when they shut their bedroom door. He told the Conservative Digest just 2 years ago, quote, I don't think there is a supportable method of constitutional reasoning underlying the Griswold decision. Now, there is an interesting, in respect to my surroundings, I'm trying to be objective about this, but there is an interesting discrepancy here. In trying to reassure the Judiciary Committee that he was not determined to overturn Roe versus Wade, Judge Bork said that if such a case came before him, he would say to the lawyer, "Can you justify this decision for me? Where in the Constitution do you find this right?" And of course, if he were satisfied, he would support the precedent already established. But as we have also seen, to other cases, to other audiences, he gives a very different view. In a speech in 1982, he spoke of both Griswold versus Connecticut and Roe v. Wade and said, quote, "In not one of those cases could the results have been reached by interpretation of the Constitution. And of course, these, of course, are only a very small fraction of the cases about which that could be said," end quote. Now, I don't know what the other cases are. I hope never to find out. I do think it is useful to stop for a moment and reflect on the irony here. The fact that in 1987, in the closing years of an anti-abortion president who has pledged to appoint judges who support his principles, that we are watching a fierce struggle for confirmation in which the president's appointee goes to such lengths to claim that he is not anti-abortion at all. The extent to which the American people firmly support their right to privacy, the use of birth control, and the option, should it ever be needed, of safe and legal abortions, the extent to which these rights are now overwhelmingly accepted can be deduced as easily by what Judge Bork and his supporters are not saying as by what they are. The issue of privacy, which I was asked to talk about months ago, has never been more relevant. And so is the issue of due process and equal protection, those clauses, now ringing phrases, from the 14th Amendment. Robert Bork's reading of the 14th Amendment is so narrow, so restricted, he does not believe it should have been used to ban the use of a poll tax or to strike down state enforcement of racially restrictive real estate covenants. About the poll tax, Judge Bork has been quoted as saying it was, quote, "a very small tax," unquote, which suggests a constitutional distinction between small and large payments for the privilege of voting. He attacked the Supreme Court for insisting on fair legislative redistricting, reverting again to his familiar argument, in this case, that adherence to representative government went beyond the intention of the framers. At one point, Bork told the Senate that by the principle of one man, one vote, the Senate itself might be unconstitutional. Here, the noted scholar apparently forgot that the founders took care of any such problem by stating explicitly in Article 5 that, and I quote, "no state, without its consent, shall be deprived of its equal suffrage in the Senate," unquote. I can find no such textual reference to state senates or state legislatures of any kind. But in this particular restricted view, Judge Bork tells us the 14th Amendment, the home of equal protection and due process, applies differently to different kinds of discrimination. In an interview given this summer for an international audience, Bork said, quote, "I do think the Equal Protection Clause should have been kept to things like race and ethnicity," end quote. That, I need hardly point out to the audience, omits sex discrimination. Now, this was a WorldNet interview beamed out by the United States government to an international audience. I have since wondered if Mrs. Thatcher was watching that day, or Corazon Aquino, or what they would have thought. There are serious consequences to a line of reasoning which limits the ability of women to rely on the 14th Amendment. Cases already decided which use this clause include those which declared invalid different Social Security benefits for men and women, and we used to have them. We had laws of automatic preference for men over women as executors in family estates, and we used to have them, and the 14th Amendment was the reason they were ruled invalid. And state statutes which once gave husbands exclusive authority to manage property jointly owned by the husband and wife. And we used to have those statutes, and it was because of the 14th Amendment that we don't have them now. And we have more contemporary evidence of the result of judges who distinguish between racial and sexual discrimination in providing due process and equal protection. Robert Bork has said last year, maybe the year before, in an opinion which was unanimously rejected by the Supreme Court, he said that sexual harassment cases should be harder to prove and subject to different standards than other discrimination cases. In language reminiscent of the old "she asked for it" theory of excusing rape, this judge said, and I quote, "In this case, evidence was introduced suggesting that the plaintiff wore provocative clothing, suffered from bizarre sexual fantasies, and often volunteered details of her sex life to other employees at the bank. While hardly determinative, this evidence is relevant to the question of whether any sexual advances by her supervisor was solicited or voluntarily engaged in." End quote. And this for the case of a bank employee whose rights and whose claims of sexual harassment, as I say, were unanimously upheld by this Supreme Court. Now, it can be no surprise that American women watch today's hearings with concern and with apprehension. We were not admitted to the first writing of the Constitution. We will be included from here on in. I am reminded of a conversation between Congressman Emanuel Seller, who was then chairman of the House Judiciary Committee, and Congresswoman Bella Abzug. Congressman Seller, as chairman of House Judiciary, never would allow the Equal Rights Amendment to emerge from his committee. He pointed out to the Congresswoman that women had not been present at the Last Supper. "That's so, Manny," Congresswoman Abzug replied, "but we'll be at the next one." We are here, in the hearing room, if not yet at the Senate table, in the staff room, and in the ranks of organizers, lobbyists, and public interest monitors lining the walls and working the phones. We are speaking out to the Senate in letters and telephone calls, and we are speaking to one another in large meetings and small to spread the word of what is at stake. This nomination will be decided within a month. What once seemed an easy win by the White House has turned into a fierce, pitched battle between evenly matched sides. And whatever happens, I will take bets when the formal part of this meeting is over. But whatever happens, we know the debate will continue. The issues of privacy, of due process, of equal protection are essential to the lives led by real men and real women in this society. The Supreme Court was not meant to be the legal version of colonial Williamsburg, recreating a 200-year-old society for the benefit of tourism. We are not talking about hypothetical exercise. We are talking about the realities of our daily lives. And it is on this question, that of reality, that I want to conclude. When we first started talking about a title, Bob Alley suggested privacy, and he added personal autonomy. And he was, as usual, absolutely correct. Without the right of privacy, there can be no personal autonomy. A family that cannot use birth control can hardly be said to control their own family destiny. A woman who cannot control her own reproductive life cannot hope to achieve personal autonomy or economic independence. An America in which due process is restricted to narrow 18th or 19th century terms deprives millions of Americans of their personal freedom. Americans who no longer can look to a constitution that protects them against a poll tax, which interferes with their right to vote, in which racially discriminatory covenants do not impair the 14th Amendment rights of black citizens. In that country, we would all lead different, more narrow, less free lives. American women who are not protected from sex discrimination by the Constitution, who must defend their choice of clothing if they want to raise the issue of sex discrimination, who must be prepared to argue individual by individual, case by case, their right to be treated as equal citizens. American women who wake up and find themselves in such a country will know they are less free. Their loss of personal autonomy will diminish their rights of citizenship. And if that is the fate of millions of Americans, our nation will be less free. The expansion of democracy over the last 200 years has strengthened our democracy. The extension of civil rights and voting rights to more and more of our citizens has expanded, extended, strengthened our nation. If anyone doubts that the Constitution of the United States is both a historical and a living document, come with us to the Senate caucus room this week. If anyone questions the interest in and the commitment to the rights of privacy, of equal protection and due process, listen to the hearings on the nomination of Robert Bork. I think the spirit of Thomas Jefferson is in that hearing room. I think he cares enough about the Constitution and about this democracy to leave Monticello. I think James Madison is there watching, and Abigail Adams. Abigail Adams, after all, during the writing of the Constitution, wrote to John and urged him to remember the ladies. She, of course, was back on the farm making enough money for their family to live on. He thought it was a joke. I think Abigail Adams likes what she sees in the hearing room these days. and Harriet Tubman is with us, and Frederick Douglass. They want to watch and see what direction our democracy will go. So many people are watching because there's so much at stake for all of us. I'm delighted to have this opportunity to share with you today my own observations on the Constitution. I thank you once again for waiting for us. I'm so sorry we were delayed. Thank you for your attention. I look forward to speaking to you again.
Ms. Lewis, thank you for a stirring address on the vitality of the Constitution today, because of the debate that has us all involved and examining this important document in this important court. Let's look at another aspect of the debate, the continuing debate that you've asked us to examine. Let's now look at equal protection, gender, age, and economic status. And let's ask Kathy Bonk, the National Organization for Women Legal Defense Fund, to continue the debate for us. Ms. Bonk.
Well, I don't know how much I'm going to be able to continue this debate. Last May, when I agreed to come here, I thought I would be finishing 2 weeks at Outward Bound, and I would be rested and relaxed and could leisurely read through all the cases that were outlined in the proposal. And somewhere between here and there, my life took a turn, and the last 2 months I've been organizing media campaigns on the Pope, against Bork, and for Pat Schroeder. So I never got to Outward Bound. I was on the airplane, though, from Washington to Richmond. My stomach is somewhere in Culpeper. I was sort of reliving La Bamba and Sweet Dreams. And if I can get a noun and a verb together, I'll be in good shape tonight. And just so I don't end up in the mess that Mr. Biden's in, for the record, I want people to know all of my thoughts are not original. Some of them came from this article in the National Law Journal from my colleague, who's our legal director. Some came from the National Law Journal again, and a few from press releases and this report that we all did on setting the record straight on Bork. No, seriously, I came down here tonight, and this morning I was sort of thinking of every excuse in the book. You know, my back went out, the kid got sick. I would probably go like a lemming in the sea to follow Bob Alley and Professor Brown, because I consider them dear close friends. Then when a thunderstorm struck, I thought, well, this will be great. You know, the plane will be late, and I can figure out what I'll say. And then the sun came out, and I decided, no, I really wanted to come here tonight. I'm living a real hectic schedule right now with Pat, and I sort of know what she said to you last night, because I've been traveling with her, and I've heard the speech a couple of times, and we talked a little about what she should say and how she should say it. But I'm not an attorney. I've worked a lot with the Constitution, however. I spent 10 years of my life almost trying to amend it. I've brought a number of cases before the Supreme Court, organized cases before the Supreme Court, and in the last 2 years have specialized in working with Supreme Court reporters to interpret those cases so the average person can understand what they mean, to take them from the legalese down to the 3-word headline and the 30-second bite on the nightly news. We've had 20 cases on sex discrimination, age discrimination, class discrimination before the court the last 2 terms. And what I'd like to do tonight is, in addition to talking about the Equal Protection Clause, which comes up a lot in the last 20 years, is go back a little bit and share with you my perspective of where we are on women in the Constitution. It was actually, the historian in the room can maybe correct this. There's actually been a debate on the Abigail Adams quote. Was it during the Second Continental Congress or the development and the writing of the Constitution? But let me share with you that quote, because I really think it's important. Abigail wrote to her husband and said, "In the new code of law, which I suppose it will be necessary for you to make, I desire you to remember the ladies. and I can't remember, and be more generous and favorable to them than your ancestors. Do not put such unlimited powers into the hands of husbands. Remember, all men would be tyrants if they could. Give up the harsh title of master for the more tender and endearing one of friend. For the last decade, the work we've been doing, especially in the area of family law, has been underscored with the notion of equal partnership in marriage, equal partnership in business, women getting and earning and winning their full rights. Unfortunately, Mr. Adams responded, "We know better than to repeal our masculine system." And around the same time, Thomas Jefferson said, "Were our state a pure democracy, there would still be excluded from our deliberations women, who, to prevent deprivation of morals and ambiguity of issues, should not mix promiscuity in the gathering of men." Now, if I had a good quote from St. Paul, we could combine the Bork hearings, Biden's plagiarism, the 200 years of the anniversary, and the Pope's visit, but I don't have a St. Paul quote with me. As many of you probably know, women in this country started out in most of the colonies of property of men. That's not true of some of the states that were settled by Spain. The concept of community property in those states settled by Spain versus those states settled by the English common law principle. We had the rule of thumb in many states where it was legal for men to use a ruler or a stick on his wife, provided it was no bigger than his thumb. Women were excluded from universities under the principle that if they used their brain, it would draw blood from their uterus, and in fact, remove the most important function from their lives and damage their reproductive organs. The famous Pat Schroeder quote is when her first day of Congress came and one of the men and colleagues came up to her and said, "How can you have two young babies and be in Congress?" And she said, "I have a brain and a uterus and they both work." Well, in the last century, that was not true for most women, and many women were banned from universities and banned from education because of the myths that surrounded them in terms of their gender. Now, what should have happened 200 years ago today? I think two things should have been included in the Constitution. One, for women, the positive power of full participation in government. Voting powers, the power to hold office, the ability to sit on juries, as well as being taxed. Secondly, I think the Constitution should have included some mechanisms to redress the already imbalance of sex discrimination. Our culture, our legal system, and our economic system was really based on the subordination and segregation of women. Of course, we know neither of those happened. There was a 10th Amendment that basically set up the principle that everything not delegated to the federal government or prohibited by the states was to be reserved by the state government. Thus, family law in this country and most of the laws covering women, by and large, in the first 100, 150 years, were settled at the state level, which meant women had to deal in all 50 states and work their rights from one state to another. That's one of the reasons why the suffrage movement was formed. We couldn't get voting rights state by state. It was like plantation by plantation going after the elimination of slavery. What emerged was sort of the separate sphere system, and it stayed in place. It really stayed in place till 1971 in this country. And I've had the privilege of living through and being around and observing many of the major cases that have come forward since 1971, and I want to tell you a little bit about that. Ironically, for the first 100 years, women who did own property were subject to the laws of taxation, but they had no representation. Post-Civil War, 14th Amendment, it raised some hopes for women and for activists like myself, my four sisters back then, that maybe, just maybe, the 14th Amendment could bring equality, could provide voting. maybe, just maybe, Abigail Adams' equal partnership concept could actually emerge as the law of the land. There were early test cases, and we lost. Bradwell v. Illinois is probably the most famous of those in 1894, when she was denied admission to the bar after having graduated from law school. It took 50 years, 50 long years, to win the right to vote. We didn't get the right to vote. We fought for it and won. Now, probably one of the early cases is the Mueller v. Oregon case in 1908, which really defined a special role for women. And this was a equal protection case, and it really established back then the notion of special protection for women. This was right during the suffrage phase. And there were a lot of problems when in this country we protected women. Frances Perkins, for those historians in the room know, that she started in New York State, hoped to get child labor laws extended to all workers. When she couldn't get protective labor laws for all workers, she took the kids and the women. And what basically happened in this country was the beginning of a sex-segregated workforce that created different wages for men and women. It put the women and the kids over here and the men over here. Post-World War II, it was absolutely legal to pay those women less than men. 30–40%. Westinghouse, in one of our big cases, we had to point out to the court that post-World War II, when they did job evaluation programs, it was perfectly legal to pay women 40% less. It was written into their job evaluation manuals, pay women less and segregate them apart. Today, the reason why there's a wage gap, 60 cents, 70 cents on a dollar, is because we've inherited those principles that were developed in that period between 1908 and 1971, when some of those statutes were first struck down. Now, I got involved in the women's movement when I was your age. I was in college and I was hitchhiking one day, and one of the feminists in my community, I went to the University of Pittsburgh, picked me up. She was running for office, and as a Republican, and we all started working in her campaign. And I was the student organizer, and Ellie Smeal was the homemaker organizer. And I saw Joanne the other night in Houston, and she was still organizing college students. She's in her 70s now. And I feel some days that those were the days when we were in Joanne's front room that we got more done for women than probably all of our fancy offices today, and meeting payroll and raising grant proposals and becoming institutionalized. We started a lawsuit in Pittsburgh called the Pittsburgh Press case. It went all the way to the Supreme Court. And Joanne's husband was a PhD, and she told him, she challenged him one day, and she said, now you go with your credentials and look under the Help Wanted Women's column and see if you can get a job. Prior to 1971, the way the newspaper want ads were set up is Help Wanted Men, Help Wanted Women. And he couldn't find a job. He had a PhD in mathematics, and the best he could do was key punching at about $30,000, $20,000 less than if he were a male looking for that job. So we started a lawsuit. Started at the local level, we worked our way up through the Human Relations Committee, we worked our way up through the state courts. Finally, at the Supreme Court level, the case came down, and instantly, within 2 or 3 months, practically every paper in this country changed to Help Wanted. No men, no women. It was a hard struggle. I learned a lot. I was about 20 years old, and that was really my first exposure to the law, to the Constitution, to what I could do as maybe being a lawyer or a non-lawyer. And I guess for the people in this room who are already lawyers, it's too late for you. You've already done it. But for the people in the room that are maybe thinking about becoming lawyers, or thinking about what do you want to do with the rest of your life, I'm going to advocate maybe not going to law school, but thinking about how you can use the law to your best interest, but to stay on the cutting edge for that next generation. And I'll explain a little bit of that in a minute. In 1971, It was really the landmark year for women in the law and the Constitution. The period between sort of post-World War II and the early 1970s now was founded in 1966. And it was founded because under Title VII of the Civil Rights Act, the part about eliminating sex discrimination was not being enforced. Now was founded in the basement of the Washington Post at a meeting of all the state chairs of the commissions on the status of women. They got together and they scribbled out on a little note, National Organization for Women, not of women. They wanted men to join. There were about a dozen men in the room at the time. And I was privileged this last fall to be at a meeting of the 20th anniversary of the Now Founders, really led by Martha Griffiths, who's now Lieutenant Governor of Michigan. She was in Congress at the time. And it was this band of women that really worked in the 40s and the 50s and the 60s. It wasn't the Betty Friedan's. Betty takes a lot of credit for Now and the movement, but she really was no more than sort of a front person. It was about 40 or 50 women, mostly lawyers, who had been over those 20 years been working away at that equal protection clause in the Constitution. The debate over do we need an ERA really was, can we get our equal rights through the 14th Amendment, or do we need a separate amendment? Prior to 1971, the Supreme Court had never ruled that, in fact, sex discrimination could be eliminated through the Constitution, which was part of the fight in the early days. It wasn't whether or not there should be an Equal Rights Amendment, whether or not women had equality, or how to achieve equality, or what equality meant. It was, can we do it with the Constitution we currently have, or do we need to amend it? The period from 1971 to 1978 was really an exciting period. The first landmark case was Reed versus Reed, where it struck down the sex discrimination statute for the first time. From there, it was a combination of Supreme Court cases and lower district court cases. Griggs v. Duke Power, where a woman who wanted to be a lines person because it paid more money than an operator finally challenged AT&T and won the right to get more money and go into a non-traditional job. The Pittsburgh Press case, Roe v. Wade. Remember, Roe v. Wade was not really a women's rights case at the time. It was a doctor's rights case. It was promoted by the medical profession, and women were kind of bystanders in the process. There was the pregnancy disability case, which was our first big loss at the Supreme Court. All the other circuit courts had ruled, yes, in fact, women have certain rights when they're pregnant. It got to the Supreme Court. They reversed every court decision under them, and we had to go back and fight for a new law, the Pregnancy Disability Act. Studies that came out during that period, the 70-78 period, showed that, in fact, women were gaining more rights through legal cases than they were through legislative victories and legislative battles. One right after another. They were primarily employment cases, which has changed, and I'll explain that in a minute. The period from 1978 to 1984 was really one defeat after another for women. The draft registration case, wage discrimination cases, military wives case. Probably the biggest setback came in the Grove City case under Title IX. Many of you in this room may be somewhat familiar with that case. When I went to high school, I graduated from high school in 1970, we weren't allowed to play basketball. We weren't allowed to play sports. We had a basketball game once a year called the Yale-Harvard game, and the girls got to wear the boys' uniforms, and the boys dressed up as cheerleaders, and we got to dribble the ball for one day, and the boys were out there cheerleading for one day. It was like a freak show. That was it for women in sports. In 1972, 1974, some new laws and some new regulations were developed, including Title IX, which changed all that. I vividly remember driving back to my home one day. It's Brooklyn, Ohio, when at the corner where you drive in, it said, "Welcome to Brooklyn, Ohio State Girls Basketball Championship." And I thought, my God, this law, within a very short period of time, opened doors for women that were never there before. After those defeats, I believe the women's movement got a little complacent. We stopped bringing cases. and we pretty much moved in sort of a amicus brief mentality, if you will, till the last 2 terms of the Supreme Court. We had 10 cases before the court, the 86 term, 10 cases in the 87 term, and I want to talk a little bit about that, and then talk about where I think the Constitution is going, and especially the Constitution under Bork. The kind of cases the Reagan administration brought were just like the case we saw in Grove City. And let me tell you the special kind of case they looked for. It was a case where they didn't have to come out against the statute, but what they did is found a case that that statute could be very narrowly interpreted. If you'll remember in Grove City, it's a small college in Pennsylvania, and it had to do with whether or not coverage under Title IX covered the entire university or just the part of the university that got federal grants. In many universities, that's basically the student aid program, and that's it. It would exempt the sports programs, it would exempt any kind of scholarship programs, it would exempt practically the whole university. So and this is sort of where my job comes in. The morning that case came down, the Reagan administration interpreted that case as a victory for women. We saw it on CNN and we said, wait a minute, this is not a victory for women. We had to reinterpret what happened in that case and point out that it was a big, big loss for women and what that meant. So the 10 cases that were brought up in the last 2 years, 3 years, have dealt with a range of women's rights issues. And there's a reason for that. The cases that were started 10 years ago, 5 years ago, are now maturing. They've gotten up to the Supreme Court level. There was an important decision on abortion in the last 2 terms. We won that case. Now, it was a case that had we lost, abortions could be made illegal in many cases, in many states, but we won it. Very narrow, 5-4 decision, but what was established in that decision was the right of a woman to get an abortion, and that was a very, very important distinction. Affirmative action, again, Reagan administration looked for the perfect case. They could come down on the side of supporting the statute, supporting the program, but reverse it and got it so badly that it would be a setback. Johnson v. Santa Clara County was the case. You may remember it. It's my job to take the case, once it comes down, reinterpret those headlines, and make sure everybody understands what happens in those cases. It was the first time the Supreme Court reviewed sex-based affirmative action. Prior to that case, it had basically been ruling on race discrimination. We had a lot to lose. We won that case. In fact, they confirmed that affirmative action plans on the basis of sex were constitutional and were covered under the 14th Amendment. Then there were 2 cases that I call immediate impact cases, one on sex harassment, the Vincent case that Ann told you a little bit about, related to whether or not the EEOC could adopt regulations and extend the definition of sex discrimination to include sex harassment. Reagan administration said no. Congress never passed that law. It was just a regulation that Eleanor Holmes Norton extended. In fact, we won. We won that case unanimously. Then there was the Men's Only Club case. There had been prior cases on the questions of the Kiwanis and the, you know, as I call them, the zoo. It's the lions and the tigers and the bears and the mooses and the elks, right? The earlier cases really didn't open up those men's clubs. This case did. Again, it was a very narrow case. We could have lost our shirts. We could have been set way, way back. But in fact, we won that case. And I think you can see the change in your community. I can see it in my community. I live in Annapolis, Maryland. Now, my local Democratic club only does not admit women or blacks, but the mooses and the elks are starting to open up. So we'll see what happens on that one. But there's an interesting shift going on in the court right now, and one that I hope as observers, or as at least people that might be interested in the Constitution and the Supreme Court will take a look at, and that's more and more family issues are before the court. There was a big case this last term called California Federal, Cal-Fed, where they looked at the issue of pregnancy, discrimination, and parental leave. Now, the women's groups were split on that case. but we were all unanimously against the administration. In fact, probably we got one of the single best decisions we could get out of it. This last term, there were several cases on child support, on parental obligation. Again, slowly, we had a lot to lose, but slowly, chipping away, we picked up. So I think that what's going on right now in the court, what's going on in the Constitution, especially under the some of the 14th Amendment provisions, especially relating to sex. It's not true of age, it's not true of gay rights, is slowly we're moving from cases that relate exclusively to employment to cases that are now looking at the issues of family and family issues. And I think that that's very, very important to watch. But it all brings us down to, do we or do we not need an Equal Rights Amendment, which is what I hope we can get into in the question and answer. The debate that took place in the 60s among the early lawyers of the women's movement was, let's do it under the 14th Amendment. We don't need an Equal Rights Amendment. We needed an Equal Rights Amendment. The issue was very different then. I think the question now is, do we go for that amendment, or do we keep relying on those slow but steady gains that are coming down under the 14th Amendment right now? Now let me just say, as far as the court cases of the last 2 terms have been small and sweet victories. They haven't been tremendous successes, and it's in part because we didn't control the cases. They were cases that were out there that the administration brought up. In the case of Roe v. Wade, we had control over that case. We had control over who the women were. We had control over some of the legal arguments. The Vincent case was a case that was kind of out there that got moved up to the Supreme Court. It wasn't the best factual situation, and we really lucked out, I have to say. Now, getting back to that question of do I or do I not go to law school, and the lawyers in the room, and what do we do with this Constitution, and where do we move as far as women are concerned? When I moved to Washington, I worked at the Justice Department for 5 years in the Civil Rights Division in the voting section, and we monitored, enforced, I guess, the Baker v. Carr decision. The research analysts did the same thing as the lawyers. It was great for me because I was a research analyst. We covered the elections in the South. Every time there was an election in Mississippi or Alabama or Virginia, we were the federal observers that went down. And every research analyst there wanted to be an attorney. And that was sort of the way up to the top at the Justice Department at the time. Even I took all those tests and, was all ready to start all the applications. But I have to say, we really need people that aren't just going to go to law school and get emerged in some big law firm and practice tax law or something. What we really need are people out there that look at the Constitution, read these cases, and keep the law for women's rights on the cutting edge. And basically, by and large, those kind of cases are not going to come out of fancy law firms in Washington. They're not going to come out of New York. They're going to come out of places like Virginia, North Carolina, Alabama, Washington State. We had a big pay equity case out there. And so I would appeal to the people in this room to keep that kind of activist flair and activist flavor in your life. Maybe not go to law school. Maybe think about other ways you can use and test the law as an individual, and I guess keep it at that cutting edge. Now, for the lawyers in the room, there's a pro bono spirit out there that we're not seeing much of anymore. This sort of decade is kind of part and parcel of, I think, some of the problems we've got with some of the lawsuits that we don't have out there right now. Take on a few cases. Start hanging out at the Domestic Violence Center or the YWCA or some of the consciousness-raising groups that are beginning to reemerge again. Some of the clients out there really need your help. And just like we took on that little Pittsburgh Press case back in the early 70s, never thinking we'd be watching it argued at the Supreme Court, I would propose that you start thinking and doing a little bit more, dreaming of where do we take this Constitution from here. So hopefully we can open this up for some discussion, and my knuckles are still white from that airplane ride.
I must say I can enthusiastically endorse about 95%, 99% of what Ms. Bonk suggested to us. I think my faculty would be very upset, however, if I associated with the encouragement not to go to law school. I believe that you're right in some respects, that there has been an absence of the pro bono spirit among law students in relatively recent times. I think that's changing. I think there is more excitement today than there has been for a decade about important and critical issues, and I see more and more people looking for the opportunities in public service. One of our problems, of course, in the law is many of those opportunities have disappeared. This administration has taken away the kind of support, financial and moral, for legal services, and the kind of programs that have been enthusiastically supportive of many issues. Before we get to your questions, I'd like to turn to one of our at-home experts to respond to the comments that of our guests. I'd like to turn to someone we've just brought back home to the university from his sabbatical at the University of Utah, a member of our political science department and an expert in this area, Professor Tom Morris.
Well, I know what my role is tonight, and it's to be brief, and I will do that. Let me just first make one observation, and that is with regard to the two speakers. They obviously are articulate, well-informed, active political organizers, and it seems to me that as we talk about women in the Constitution or women in politics, that's a very important observation to make, and I guess I would second Ms. Bonk's plea for people to be active in the political process, regardless whether they choose to enter the legal profession or not. And I guess I would argue that tremendous strides have been made in the women's movement, particularly with regard to political organizing. Certainly one could argue that there's a ways to go. And here in Virginia, certainly West Hampton graduate Mary Sue Terry is well on her way to demonstrating her potency in the somewhat traditional Virginia political structure. But political organization, I think, is very important. Now, let me, since there's been a lot of talk about Judge Bork, and Judge Bork suggesting that when he wrote articles as a professor, he was simply being provocative, let me, even though I'm someone who has 4 daughters, attempt to be a little bit provocative in the next couple of minutes with regard to some of the comments that have been made. And like Judge Bork, I'm certain I will not later regret having been provocative tonight. With regard to women in the Constitution and the Equal Rights Amendment, Justice Rehnquist is correct that the drafters of the 14th Amendment did not have in mind women when they drafted that particular provision of the Constitution. And it is true, I think, that Justice Bork, or Judge, oh my, what a slip, Judge Bork, who is attempting to become Justice Bork, would embrace that similar sort of position, and like Justice Rehnquist, would not contribute a great deal to the debate on the United States Supreme Court in the area of sex discrimination, primarily because they would not choose to use the Equal Rights Amendment in sex discrimination cases. However, we might also ask, since the Equal Rights Amendment was brought up, what does the rejection or the failure to ratify the Equal Rights Amendment mean for women and the Constitution? Our own Justice Powell, who has created this excitement in Washington by stepping down from the court and opening up a vacancy in the Frontiero versus Richardson case in 1973, in which the court did begin to move in to protect into the area of sex discrimination and protecting women's rights, refused to go along with Justice Brennan's opinion in that case, when Justice Brennan suggested that sex should be a suspect classification and the strictest sort of scrutiny should be used whenever legislatures choose to use sex as a basis of classifications. Justice Powell wrote a concurring opinion and went along with the decision in that case, but said maybe we should wait to see the outcome of the Equal Rights Amendment. Well, that was a long, hard, drawn-out struggle and we may yet have another battle along those lines. But the fact of the matter is, the Equal Rights Amendment was not ratified, and indeed, the Supreme Court, no Supreme Court majority has, in essence, determined sex discrimination to be a suspect category. So what that means is that, as far as the court is concerned, that sex as a classification has been sort of put into a semi-suspect category, which means that, as is often the case in life, sex has provoked a methodological crisis in constitutional interpretation. The justices have not been certain exactly what to do, where to put that in the scheme of things. And indeed, I think, given the failure to ratify the Equal Rights Amendment, are justified in not making that a suspect classification. That does not mean, however, that a majority of the courts have not clearly embraced, as Ms. Bonk set forth, the fact that the 14th Amendment can be and has been in many cases used and will continue to be used to protect the rights of women. I also would point out, as one who operates in the area of state constitutions, that a good number of state constitutions do in fact have equal rights amendments, and what we have seen is a revitalization of state courts and also of state legislatures that have reformed much of their many of their sex classifications, so that there has been a revolution going on, spurred in part by court decisions, but also spurred by political organization and the increased political impact of women in state legislatures. So one does not always have to look at the United States Supreme Court or indeed at the United States Congress. There are other places to look, and as the number of people interested in this issue continues to increase, there are other fora in which to fight these battles, state courts and in state legislatures. But so the equal right rejection does come into play, I think, as we look at the 14th Amendment. The other issue, and then I'll stop and let you ask your questions of the speakers. Ms. Lewis talked about the right to privacy. That, of course, is a very important issue and one that's been controversial as far as the United States Supreme Court is concerned. Justice as eminent a justice as Justice Black, who took a very strict construction of the Constitution, pointed out in Griswold back in the mid-1960s that there is no right to privacy enumerated in the Constitution. And indeed, he had a great deal of concern whenever justices of the United States Supreme Court moved too far away from the text of the Constitution. Judge Bork has put himself right in the middle of that controversy over constitutional interpretation. And it is a legitimate one. It's one that's gone on for 200 years, as long as the Supreme Court has been interpreting the Constitution, which is, to what extent should the court, invoking natural rights and emanations from other provisions of the Constitution, create new rights, whether it be right to travel or right to vote or right of privacy. It is true, I think, that Judge Bork has chosen to align himself with the dissenting viewpoint in most of the landmark cases that have been handed down over the last 15 or 20 years. And that might be, in and of itself, some commentary on his qualifications to deal with cases over the next 20 years or so, since justices now seem to serve to 80 or more on the court, and he's only 60. The fact that he's associated himself with dissenting opinions in the past is perhaps something to be taken into consideration. And yet, simply to put in one good word for Judge Bork tonight, he, in essence, has aligned himself with some distinguished scholars and some distinguished members of the court who have cautioned justices of the Supreme Court to be careful when they begin to move too far away from the specific language of the Constitution. I mean, what will be used to restrict, to confine the concept of right to privacy? What will stop the justices from, in essence, simply having that be whatever their own particular value system happens to be in an individual case? It is a legitimate argument. It is not necessarily a refutation of the notion that, in fact, that there is a right to privacy and there is some textual support in the Constitution, as Justice Douglas pointed out in his Griswold opinion. There are emanations from other parts of the opinion: the First Amendment, the Fourth Amendment, the Fifth, the Ninth Amendment. There are other areas in which clearly right to privacy has been acknowledged by the Constitution. But I would suggest that that is a legitimate, that is an open question, and certainly there's more than one side to the question of right to privacy and how far it should be extended. But let me stop at that point.
I'd love to get into this debate, but what I'd really I'm forced to do is to ask you to get into the debate. Do you have any questions? Do you have any comments for our guests or for Professor Morris? Yes, ma'am.
In the readings that I've done, it has come to, particularly this summer, there was a group of papers put together for an institute done at the University of Virginia, and I think Anne was there, I'm not sure. There were some papers put together, legal papers, not only case papers, but law journals, and in preparation for the project that I had participated in, I was not able to read the papers. What I gleaned from the papers, and I'm not a lawyer, but what I gleaned from the papers that I was reading is that there is currently a debate in women's rights circles as to the direction that should be taken in arguing for our protection of the Constitution. And that because the assimilationist kinds of decisions that we have been granted using the Equal Protection Clause and possibly the Due Process Clause, I'm not sure, certainly the Protection Clause, that those cases have assimilated us to basically a male standard within society. And that society has not yet, within the legal system, been challenged on its molding in the male model. Okay. And therefore there is currently, and this is seen as something that we do need to possibly challenge, but the course for doing that is not articulated yet, or was not articulated in anything that I've read, and is currently, as I understand it, in great debate, which may be one of the reasons why we aren't getting anywhere at the present time. Another point made in those papers was that the laws we currently have, we hope that the 14th Amendment, for example, inasmuch as it was not meant originally for sex discrimination, has not allowed the generation of laws. In other words, the legal system is a reactive system in that instance for women's rights rather than a generative system in protecting us. How do you see, that we are still sort of trying to figure out how we should go legally in protecting women's rights? Whether we continue the assimilation model or whether we try for something where, that was said in the Duke case, where the stork and the fox have to be able to drink the milk out of the same, have equal access to the milk. Let me stop.
Who wants to begin?
I'll start, sure. Well, I think what you just said is, and it's an argument that has been going on actually since suffrage. Are we the same or are we different? Is kind of putting it in very simple terms. There's that element. No, I realize that, and the debate really came to a head on the Cal Fed case this last time before the Supreme Court. In that, let me try to explain it. The state of California adopted a rule mandating pregnancy benefits for women, employed women. Historically, whenever you've had a separate piece of legislation protecting women in any way, shape, or form, it's been an invitation to discriminate against women. That was especially true pre the adoption of Title VII. Well, California Federal passed this law that affected just pregnant women. And under Title VII, there's in the regulations that you cannot pass laws affecting just pregnant women, knowing that in the past, when those kind of laws were passed, it worked against employed women. I mean, it put them in a separate category, and it was an invitation to discriminate. So there were two points of view among the women's community. Now, the Reagan administration and the California Federal, which was the savings and loan that brought the case, wanted to do away with the law. They didn't want any coverage at all. The part of the women's community argued that the law affecting pregnant women should be extended to all workers, so that if you broke a leg or if you, in fact, needed some kind of temporary disability, you would be covered. Right now, or prior to that decision, if you worked in a company that had temporary disability, then pregnancy had to be covered under that temporary disability. But you were not required to provide maternity benefits. In the state of California, all employers were required to have maternity benefits. Then there was another argument that basically said, look, let's get what we can. If only 40% of the women in this country can get maternity benefits, and if it can be adopted by mandating maternity benefits, then let's go for it. Fortunately, in the Supreme Court case, they kind of took into consideration both positions in the women's rights community. They, in fact, held the California law to be valid, but at the same time made it very clear to employers that that law should not be used to discriminate against pregnant workers. But one of the reasons why the parental leave bill is so important is it leaves us open to discrimination, and why some of us are fighting so hard to see that that law gets passed. It would provide minimum health care benefits for pregnant workers as well as male and non-pregnant female workers, so that the question of discrimination in pregnancy is irrelevant to debate. That doesn't get to your issue quite, but it was the first test among the women's community of how we were going to resolve this question, which put in very simple terms is, are we the same or are we different than men?
Please, go ahead.
I think I'm going to do it from here, not so much because I've always wanted to be taller, but I have a feeling it's hard to hear us. So let me start. One, I'm glad Kathy took on the Cal Fed case because, in fact, the issue of pregnancy and how pregnant workers are treated is clearly a substantive difference about which we don't have to spend a lot of time debating. There is, in fact, a responsibility. How do we solve it? Let me go on to a broader version of what you're talking about, which is, as you said, the assimilationist debate. And let's repeat again, we're going through some circles here. In the early part of this century, as Kathy reported, and at previous times, even in the 19th century, there has been an argument about protecting women workers. The problem with legislation that protected women workers is it then became another reason why women couldn't get the good high-paying jobs. If women could only work certain shifts, or if women couldn't lift certain kinds of, could only lift 10 pounds, for example, then obviously they were not in the same category as unrestricted workers who wound up getting the better jobs. I have personally never understood why a woman who can carry an infant on one side and a toddler on the other and a sack of groceries on her back to get home can't pick up more than 10 pounds, and none of us I know have had trouble. But the rule, what we have found out the hard way, is beware of protective legislation. It always turns around and bites you in the ankle, let us say. But it's for a moment, it may sound like fun to be up on a platform, but you can't really move around very well from there. So if we're specifically talking about protective legislation, and this was the early debate about the ERA, the initial opposition to the ERA from within the women's community was on behalf of those women who felt that the legislative protection for women workers was too precious. They had fought for it, they'd won it, they didn't want to give it up. And you ought to go back and look at some of those debates, again, even as late as the 30s, but certainly in the 20s, about it, and you will find much of the same conversations we're having today. So the first one is there a debate within the women's community on, in terms of protection of women? And I think right now that argument has almost ended. Again, the economics of the situation boil down. But you're asking a second question now, which is a more philosophical one.
Right.
Which is, again, let me go as I understand it, which is it our goal to move into the current male-structured, basically, society and adopt those current values? And is the goal of the women's rights movement or the women's movement to make that possible for as many women as we can? Or is it our goal to try to change the current structure and try to change the values? Then I would suggest that you got two questions. The first question is, do you want to just move into the current structure? Is the goal of the women's movement, every woman her own briefcase? And secondly, if in fact, if you decide, no, I really want to change this system, I don't think it works so well for anybody, is the legal system the way to make that change? And that are two separate questions that I will argue should not be confused. Let me tell you how I work it out. and that's today. And you said, is there a lot of debate on this? I assume for the rest of my life I am going to be debating with my friends what we do next and why, and I kind of look forward to it. We've had a revolution already. Think how much more we're going to do. But on the first part, are we going to change the system? It seems to me inevitable. That is, you change the distribution of people who have power, in fact, you change the system. One of the biggest problems we've got right now as a society is that the people who make our laws are too often insulated from the realities of the laws and the effects of the laws. They become almost a privileged class. As we change the distribution of people who hold power, we diminish that insulation. We make it more and more possible for people to understand that reality. I guess I would say there is no doubt in my mind, from working certainly in politics, that as you bring more outsiders around that table, whether they are women or blacks or Hispanics or people who have previously been excluded, as they get around the table, the quality of the decisions change and the number of issues that make up the agenda get changed. But if, whether you agree with me or not, that that's a worthwhile aim, and it is for me, I then have to say you don't achieve that through the current legal system. You can ask the legal system to do many things, I think, in terms of equaling out the rights, but expecting to use the legal system to change the structure of the current society is the wrong tool. The legal system reflects and, in fact, is embedded in the current structure. Now, you're still puzzled, so let me ask one more question. And then... Of course.
Okay, so that one of the systems that one can use, presumably, to then create something which is more equitable, is politics. One of my applications is analyzing Virginia politics. I am astounded in the analysis. I am astounded by how many women there are who serve in our state in an elected office in either the commissioner of the revenue or the treasurer. Those are two constitutional offices. There are 5 others: sheriff, commonwealth attorney, and clerk of court. There are some women who also serve as clerk of court. But the money, there are several women who are elected to take care of the money. What astounds me is that the women who are elected to take care of the money very rarely move from that to another office, which would then be a jumping stone into the General Assembly, for example. So, you know, I would point out to you that there is a problem also in the political system, because there seem to be certain things that when women begin to get them, they become dead end.
No, let me turn that around. To quote Frederick Douglass, power concedes nothing without a demand. Never has, and it never will. If you're not satisfied with the structure, you got to change it. But to assume that the people who presently hold power and are fairly satisfied with the system, there was something nice about being in charge, will turn around and look and see who's not there and invite you in, that won't happen. No, your problem is you're concerned that women who presently hold... All right. Yes, but you're concerned they are moving towards higher elections.
But because those jobs become dead-end jobs.
No, there's no... It becomes a dead-end job in politics if you don't use it to run for something else. But I will repeat, there is nothing in the job itself that says you can go this far and no further. It is in the individual. And that, no, I do have to finish this, because this is not...
Also within the very selective system
Oh.
in which candidates, particularly the candidates for state offices to Congress and
Let me just then end with one comment, which is nobody imposes that structure on us. Ultimately, that's what voting is about, and that's what organizing is about, and that's why Kathy Bonk 15 years ago was in somebody's living room. If you put it together, you change the system, but it will never happen of its own volition. And if you start at a very small level, you can try to change it at your level. But again, once you're through analyzing and figuring out what's wrong, what you need to do is to take on that place you're going to try to change. Then you can do it.
Thank you. Yes, sir.
Yeah, I'd like either Ms. Lewis or Ms. Bonk to go ahead and address this one comment. I just heard it on the news this evening, and I had a couple of questions I wanted to ask.
Can you stand up so they can hear you in the back?
On the evening news, I heard about a study that was being conducted, say, out of the Pentagon towards the United States Navy and Marine Corps about sexual harassment cases. And this was done in the Pacific, and a captain of a frigate had a crew of 90 crew members. of which 18 were women. And they brought this case of sexual harassment to their attention, and now the Pentagon is in total shock and amazement about what has happened and that type of thing. And I wondered if you might know a little additional information about it for us. And the other thing, two questions I had. Number one is, do you think the Equal Rights Amendment is ever going to be an amendment to the federal Constitution? And the other is, who do you think is going to take Mr. Bork's place in the Assembly?
Who do we want to hear from first?
I think you all have more information on that case because I only heard about it today.
No, but I would think, I would, on the sex harassment case, the nice thing about that Supreme Court decision is it was written in plain English. And it had some very specific examples and directions that the Supreme Court justices directed employers on. There's a question as to liability, whether if you don't know about sex harassment going on, are you liable to be sued and to be opened up? And that question is really left in the air. The court was very clear that sex discrimination is sex harassment is a form of sex discrimination, and that it is fully covered under Title VII. And I would think that the military has problems not only with sex harassment, but with child care, with equal pay. We could get into a very complicated debate about, and it comes to some of what you've raised on the question of military service and quota systems, and whether or not women should, whether or not the military should be opened up to women and mandated to provide equal jobs. And just to combine these two a little bit, for going back my 15 years, one of the issues that my friend who recruited me tried to raise when she was on the county council, they were rewriting home rule in Allegheny County, and she tried to put in a provision of equal participation in the county government, mandating that there shall be no more than a majority of one of any one sex. And you say, my God, that's outrageous, but think about it for a minute. We have equal representation on the part of geography, on other areas. Why not equal participation for men and women? Mandating full participation. And let me take this issue up to the constitutional level, because it really gets down, I think, to the question of a different voice. Is there a different voice for women? Is there a women's culture that should be represented in our public policy issues? Is that some of what you were experimenting with or not?
Yes.
There should be a human,
Right.
but the human voice should be neither male
Or female, right. In the world I work with, primarily, which is media policy, that issue is front and center before the Federal Communications Commission right now. And let me just explain how this works. Ownership. There's a limited number of TV stations that that can be owned in this country. Women aren't there. When the television licenses were given out, women were not in a position in this country to own stations. Can we have policies mandating preferences for women in owning television stations? If we can show that, in fact, if more women own stations, there will be more diversified voices under the First Amendment principle of diversity that the Communications Act represents, yes, in fact, the federal government can pass laws mandating women to own stations and giving them benefits if they do. Is that constitutional? Is it not constitutional? They already have these kind of provisions for race. Can that be extended to sex? So I kind of feel like those are the cutting issues. It's true for women in business. It's going to be true for, the question of when you have, in state legislatures, how many women does it take to start changing legislation to better reflect the concerns and the background and the history of women? To worry about the divorce laws and the family laws as opposed to the tax laws and the insurance laws. At what point do you need that critical mass to make a difference, to have full participation of women in elected bodies? And are women being denied certain, constitutional benefits if women aren't representing them or their concerns in state government? And that's some of the debate that's going on. And when I get it down to are we the same or are we different, it's sort of a code word for that big Pandora's box that has, the debate started back when Abigail Adams and the original drafters of the Constitution were there. So
Can you tell us, can either or both of you give a prediction on the next amendment to the United States Constitution?
I think if we get more women in state legislators, the amendment will pass, and it will pass within a year or two of introduction. But I don't think it's going to come under the current electoral votes that we've got right now. I think it's going to take a couple of redistricting strategies, and I just think it's going to take a better integrated group of legislators out there who are more progressive, of both men and women, who are kind of new wave, equality-minded legislators who are both men and women.
Ms. Lewis, you want to comment on that? Or?
No, I think Kathy's got it about right. As we said, suffrage took a long time. I have on the wall of my living room a letter that was written by Susan B. Anthony in 1890 from South Dakota. Now, as I figured it out, Susan B. Anthony was 70 years old in 1890, and the letter was written in August. And I don't think South Dakota summers are terrific. And I don't think travel was very good. And I've always thought that if Susan B. Anthony, at the age of 70, could make it to South Dakota to live out there for 2 months to work on a suffrage referendum, which they lost, and then she started all over again, that I've got nothing to complain about. I just got to keep going. You asked the second question, which is, who would the next nominee be, by the way, if, as we intend, we defeat Robert Bork? And that is entirely going to be White House strategy, and it seems to me they got two ways to go. They can go for a current senator on the assumption that the Senate will, for all sorts of group dynamic reasons, be more likely to confirm one of their own. Or they may just decide to make this a political, to use this entirely as political strategy for the next year. And if they did that, then I think they'd go south. Because what they, in that case, want to do is send a signal to some people that, boy, are we on your side. But we don't know either of those. You got to guess from outside.
They could also go for a moderate, like Bill Ruckelshaus, would be my suggestion. I mean, when Ann and I were in meetings, it's like, do you go for the fight or don't you go for it? Even though you might know it's a losing battle. And the view was, let's go for it because it'll moderate it. I mean, we went after Rehnquist and not Scalia, and I kind of wish we went after Scalia as well, because there's no question Rehnquist is moderated on women's rights issues. And just raising the issue and framing the debate and putting them a little bit on the defensive has made a big difference, I think, in some of Rehnquist's decisions in this last year. I think some of it is we never dreamed that we would be able to get this far with some of the arguments that are being made right now. And we're encouraged. I mean, the last couple of days have been very good.
Is there a question down here? Yes, sir?
It's evident from your comments tonight that there's been an extraordinary amount of political currency spent trying to stop Robert Bork from being confirmed. Kind of closest to me, while President Reagan, who has known this gentleman for quite a long time, waited until his political power was low ebb to have such a controversial nominee. And I wonder if perhaps this is the red herring, whether he's trying to sap the strength of his opposition. And he had a lot of Daniel Mannions waiting in the wings.
Oh, Lord.
Under the assumption that senators would say, well, media now is crying wolf because they oppose Bork so strenuously, now they're opposing this guy and the last people. So, can you comment on that? And if you don't think that's true, do you have enough political strength after Bork to continue to fight for the other items on your agenda in the coming last year of President Reagan?
I'll take that if you'd like. One, anyone who thinks that having beaten one nominee, we would have to swallow the next, ought to go back and read Richard Harris's book. I think it's called Decision, and it's really about the Carswell nomination. And in fact, that was a much tougher fight under different circumstances. Having defeated Hainsworth, if you remember, Richard Nixon, really almost at a personal peak, sent up a nominee who was far less qualified than Hainsworth, and they did it pretty deliberately, thinking, we'll show them, they'll have to take Carswell. He was, in fact, ultimately defeated simply because the Senate couldn't stomach him. Interestingly, and again, what fascinates me about that book, which I reread 2 years ago, was the extent to which it took place in almost a closed situation. The work we're doing on grassroots lobbying and modern technology and raising the political salience of this nomination simply couldn't have been done 10 years ago. So that gets me to the second part of your question, which is, are we expending political currency on this one that we won't have again? And I think it is wrong in this case to think of political organizing and strength as finite. That is, if we do it on Bork, we won't have it again 3 months later. In fact, my experience has been that it's energizing. If you can get a coalition together of people who believe in equal justice, they strengthen one another. If you have the experience of working together in your state and moving one of your senators, you work together that much more easily 3 months from now. You already know each other. You've got everybody's phone numbers, and there is nothing like a success to strengthen and invigorate a coalition. I did not ask for this fight. I would much prefer a moderate nominee. If you ask me what Ronald Reagan's motives were, I think it has to do with the internal dynamics of the Republican Party and the fact that the right wing, which has significant controls, especially over the nominating process, is beginning to get more and more antsy that they haven't gotten their share. And essentially the deal was that sort of Reagan is still controlling foreign policy, economic policy they've taken care of, and so the social and domestic issues have been given to the right. And that's what this nomination is all about. That's why it happened. I think they were not prepared for the strength of the opposition. They didn't think we could raise public opinion as successfully as we have done. They overestimated their own ability to continue to cow the Senate and underestimated our ability to mobilize and to make it a truly, again, important political issue. Well, all we have been doing over and over is saying to people, you've got a stake in this. This involves your life and your rights. As soon as people click into that, they're part of the fight. So again, I would say that if we in fact do this, we are strengthened, invigorated, and better off for the fight we're going to have next year.
I also think your analysis is right. If Bork would have had no trouble being confirmed if he were put forward instead of Sandra Day O'Connor, and we probably wouldn't have been able to marshal the kind of support against an O'Connor right now for a variety of reasons. I think several things, though, you need to put in the political analysis. First, the Mannion fight, nobody ever thought we would be one vote away on the Mannion fight. And that vote defeated a sitting senator. And I really think it's important to realize that for our side, we came closer than we ever thought we would. The other change, of course, is that the Senate is now controlled by the Democrats, not the Republicans. And I think that for all of us who kind of feel like we're finally surviving the Reagan years, was the turning point of some hope that maybe we can turn this country back around again.
Questions? Yes, sir.
You mentioned Mannion. Is the fact that there was opposition to Reagan, has that made it easier for the Senate to think on its own with respect to Bork?
Absolutely. As someone who's been working on the judicial selection process for the last 3 years, we could talk about that for a moment, because in fact what happened is about 4 years ago, a number of lawyers, public interest lawyers, people who care about this, increased their activity, which had been monitoring the judicial appointments and getting a sense of what was happening. We sort of took it a gear from just monitoring it to really getting actively engaged and alerting the Senate and serving almost in some cases as extension of Senate staff when we could, especially because the Democrats in the minority didn't have many resources about the background of these candidates. We started doing our own background check, calling into the states they came from, talking to, for example, defense lawyers and civil rights lawyers and saying, what do you know about this guy? We were able to stop some nominations. We had a couple of people who withdrew rather than get into public fights. I got into it because of a guy named Sidney Fitzwater. Sidney Fitzwater was a judge, a state judge in Dallas, Texas. In the 1982 election, Sidney Fitzwater, with his own hands, hung up intimidating signs in black precincts. I consider this behavior, to put it mildly, unworthy of a judge. And the thought that he was going to be rewarded by going on the federal bench made me furious. And I took my sign. I had a replica of the sign, because I was at the National Committee then, and took it around to Senate offices and just unrolled it. And around that nomination, we did a couple of things that were different. Essentially, we brought the community in. We reached out to civil rights leaders and said, this is what's going on. Now, this is the very first time, again, it was almost a run-through for us. We got 5 votes against Sidney Fitzwater in the Judiciary Committee. That was, at that moment, a high watermark, and that was in 1985. So you can see how we've learned to do this in the last couple of years. We made the fight on the floor. We knew we didn't have the votes, but we also knew that we were raising the salience of the issue, we were putting it on the agenda, and we were putting people on notice. And I guarantee you, we made the case that for young lawyers who hope to be judges, interfering with other people's votes is not the safe way to travel. And I knew that's what we were doing as well. Then came the Mannion case, which was our second great, again, well, we had 2. We had Mannion, who simply, on qualifications, and Jefferson Beauregard Sessions, who was a U.S. attorney in Alabama, again, who simply had racial attitudes that should have barred him from being on the bench. We were able to beat Sessions in committee. We narrowly lost on Mannion, but as Kathy has told you, we did something very important. That was turned out to be an important victory. One senator who switched his vote on Mannion in return for a deal, that became news in the state of Washington. People in the state of Washington didn't think their senator should have essentially barred his vote. He lost. Well, there is such a thing as adult education. It does work in politics. Smart politicians can count, and that in turn had a real effect. So again, the work against Rehnquist was a step forward. We did more organizing. We met each other. Again, it was another run-through. I will repeat, every time you have a campaign, you get better at it for the next time. You don't always win on the issue, but you always get better able to fight it the next time. And the work that went into Rehnquist has turned out to be invaluable in this case.
Yes, please.
Can you specify quickly what it is that you found encouraging in these first couple of days of the court hearings?
Okay, let's start with 2 things. I think on the first day, the questioning by Senator Biden, sometimes in politics you play against expectations. It's like winning the New Hampshire primary. You define winning the New Hampshire primary as doing better than the press thought you would the week before. The first set of questions were Biden questioning Bork. Senator Biden performed better than expectations, and Robert Bork did worse than expectations. Biden was concise. He kept his questions were pointed. He stuck to the Griswold case, and he in fact had some astonishing dialogue with Bork that people watching in could see this discussion again of whether or not they had rights of privacy as a married couple. That really did not ring true. In terms of establishing that he was outside the mainstream, that happened. Second, Bork had been sold by the White House for the last 2 months as his own best witness. I mean, they had him as a combination of Johnny Carson and Ollie North. He almost couldn't have lived up to it. But the fact is, he wasn't warm, engaging, and wonderful. He was sort of legalistic, no offense, really, and tendentious. And the result of the first day was a positive one, again, partly because it sent this signal. This was going to be an even fight. Yesterday, you got some debate on racial attitudes and on sexual attitudes, and the fact that Senator DeConcini, who is a very important uncommitted senator, kept questioning him and was not satisfied because Robert Bork honestly believes that sex discrimination is different from race discrimination, and that you can't treat women the same, as men, because we might, in that case, all go onto the same toilet. And that really was the issue he used, was unisex toilets. Well, after you've had 20 minutes of discussion with a man who wants to go on the Supreme Court and who thinks that sex discrimination revolves against unisex toilets, that raises some doubts. Today's paper, the stories in today's paper were quite good. They said 2 things. They said he was sharply questioned by the senators on his attitudes about racial discrimination and sexual discrimination. And second, they pointed out that he has begun changing his views. Now, we should add one other thing about Robert Bork that we'll all get to watch, which is every time he's up for confirmation, he manages to change at least one view. When he came up the first time for Solicitor General, he had written this article in the New Republic that said the public accommodations laws were a principle of unsurpassed ugliness, which is an extraordinary way to talk about the rights of human beings to sit at a counter and have a decent meal. But he said they were of unsurpassed ugliness. When he came up for confirmation as Solicitor General, he announced that he had changed his opinion on that over the last couple of years. When he came up for confirmation for the Court of Appeals, he announced that he had changed his opinion on the First Amendment. You may know he has since said, we couldn't talk about the First Amendment because it wasn't in the cases you all gave us, but he defined the First Amendment originally as referring only to political speech and not to other forms. And he repeated today that he thinks, for example, dancing and painting and sculpting would be outside that First Amendment characterization. Well, for confirmation to the Court of Appeals, he rediscovered merit in educational and scientific speech that he didn't know had happened before. And now this time, he's been slowly sort of revolving his views again on racial discrimination. This is a guy who has never written positively about any advance of civil rights for Americans while it was still current. It's like people of our acquaintance who can never find a good word to say about you while you're alive. They might be around, they might be nice at the funeral, but as long as you're alive, they don't have a good word to say. That's essentially been Robert Bork's relationship to civil rights movement over the last 20 years. He is starting to discover in himself new affiliations with civil rights, and again today, a much stronger defense against sexual discrimination. So again, we hear this, and the press is picking this up, and they too are concerned. Senator Heflin's questioning yesterday, or was it this morning? I'm losing it. I'm questioning how you could move across the political spectrum quite as far as he had. There's a certain inconsistency coming through. It's those threads that we'd pick up.
In the state of Washington, Mannion became a symbol. And a friend of mine's a bureau chief who was out there talking to a cab driver, and he said, this guy didn't know whether Mannion was a pickle or not, you know, a type of peanut butter. I mean, to him, Mannion was a symbol of their senator saying he was going to vote against him and changing his vote and switching around, and that was a wrong thing to do. And it became a political issue, not because necessarily of who Mannion was personally, but what he represented. And I think what's happening is the same, on different circumstances, is happening on Bork right now, that Bork is becoming a symbol of enough is enough on this Reagan Revolution stuff already. And I think the first big victory, as Ann said in her remarks, was when kind of inside the Beltway, Washington started to agree that the role of the Senate was not just a rubber stamp, but advising consent, and in fact, they should take an aggressive, active role in this hearing process. And I don't know if it ran down here, but Dave Broder wrote an eloquent article that appeared in Sunday's Washington Post saying this is a political appointment. These Supreme Court justices make political decisions. They decide things like boundaries on redistricting. And in fact, we've got to look at this vote. It is an important swing vote and recognize what's at stake here. Now, Dave Broder is not a flaming liberal radical. And I think the senators realize that. And so this really represents one of the first times we've been using the messages that go out to the media and the messages that go out to the senators as an important strategy to try to defeat this nominee, which is working.
We have another question here.
Yes, ma'am. Ms. Lewis, you sort of led me right into the question that I was going to ask, and I don't want to sound too legalistic, but it is a constitutional question as to what do y'all view as the proper role of the Senate subcommittee in this process. Do we look at the politics of the individual? Do we look at the way he interprets the Constitution? Is he going to be very much a traditionalist or activist? Should we really enter into a political debate as to how this man thinks of politics, or are we going to limit it to the sterile?
All right. Let me suggest, as a very quick one, I think the Senate has the responsibility to consider the same factors in their vote that the President and the administration make in selecting the nominee. That almost by definition, if I have to do it in one sentence, those factors that go into the administration's choice of the nominee may appropriately be reviewed by the Senate. Now, when I talk about politics, I think it is a very high form, a very high calling. Politics is, how do we live in this country? What kind of values do we have? What kind of choices do we make? How do we express the will of the majority and protect the minority at the same time? Those, to me, are political decisions. And I think they are important decisions in knowing about this nominee. What are his or her values? How would their interpretation of the Constitution affect the daily lives of my constituents? If I'm a member of the United States Senate, I ran for office and said to people in my state, I will be your advocate, I will be your spokesperson. I will act for you on matters of grave national intent. Very few decisions that a senator makes in his or her career will be as important as the vote they're about to make, because this is the balance of the Supreme Court from now till the next century. I think that is highly appropriate. So I am using politics not as partisan politics. I don't think his registration or his voting history matters, but if you think of politics as how we live together as one people in this society around that framework of laws, understanding that we always have to interpret the Constitution, because of course it wasn't all spelled out, then those questions are not only appropriate, I think it is the responsibility of the Senate to take those factors into account before they cast their vote.
Can I just add one thing? We talk about evolving standards with regard to constitutional interpretation. There clearly has been an evolution of standards among the members of the United States Senate as to whether they're willing to exercise the advisory consent basis on the basis of one's record and whether they're in the mainstream. When Rehnquist was confirmed initially as an associate justice in 1971, as I recall, there were about 15 senators that released a statement indicating that they considered him to be outside the mainstream and were basing their vote on that, despite the fact they considered him to be qualified in other respects. It's obvious this time there will be a larger number of senators that are basing their vote not on some technicality, not on whether he's legally qualified or not, but simply because they consider him outside the political and constitutional mainstream.
It's interesting, there's some historical support for that position during the constitutional debates. When they finally had the compromise that had the Senate as representatives, 2 representatives from each state, they changed a part of the executive branch power. Originally, the draft was written when you didn't have a Senate with 2 members from every state, that the Senate made the nomination to the Supreme Court, was the original draft, with the executive branch concurring. They made another political decision and turned that, but it was perceived that both the Senate and the executive branch were exercising political choices in the nominees. When the compromise was made on the legislature, they simply turned around who it was that would make the original appointment. There was nothing that I've been able to find or that I've been able to read historically that would indicate that at least the framers thought there was any different role for the 2 branches of government that were participating in the selection of the members of the 3rd branch of government, which at that time was only the Supreme Court. You at that time really only had the Supreme Court. It's an interesting historical anomaly that members of the Reagan administration proclaiming strict construction are arguing that the Senate can't exercise what was historically the framers' intent about a political role for the Senate. And so another question. Yes, sir.
Yeah, I'm just curious. Do you see any dangers, or just on the flip side of what you were speaking the extension of civil rights, whether you do this through the courts or through politics? Do you see any danger that in the history has its ups and downs, both progressive periods and conservative periods, that you are getting so many of your extension of civil rights that
Is essentially, is there an extreme to equality?
But you should see a danger.
No, it's a different question. I think the question I hear you raise, and then Kathy, I think, may respond. Are we weakened? Do we get weaker if we rely on the courts to grant us these extensions rather than winning them politically? And I think, again, that is a strategic debate, and the only answer, and it's an honest one I have, is you got to do both. There are issues that we cannot win politically, because to win them politically, you almost have to do it state by state. I mean, it seems that there are in fact liberties that citizens are entitled to by virtue of being born an American, and that what we learned in the civil rights movement of the 60s was that we had to approach this as a country. It was not tolerable to say that there were sections of our country where people would be treated as second-class citizens on behalf of race. That became a national decision, and that got won in the courts as it should. But immediately following that, you had the Voting Rights Act, which made it possible to solidify through political means those same gains. I think if we had only had the court decisions and not had the Voting Rights Act, those decisions would be vulnerable politically. But because we now have black Americans exercising their right to vote, those gains are secure. So I guess my argument is I think you have to do both. You have to carry out both at the same time, understanding that in any given year or 2-year cycle, one or the other is going to work for you. But when you're trying to achieve social change and justice, I don't think you discard either avenue to get there. You just plan your strategies so you can rely on both at the right time.
One has to believe if we've got 3 branches of government, we ought to pursue all 3 branches simultaneously to achieve ends that we think are appropriate, whether it's within the executive branch, the legislative branch, or another political branch, at least at the level of the Supreme Court of the United States, the judiciary. Yes, ma'am.
Yes, I've been reading some things recently about how long it will take women to reach parity or equality in political office, appointed office, and I was just wondering, and the statistics seem absolutely incredibly depressing to me, can we as women, being at some point between 50 or 53% of the population, can we hold out hope in the near future that we will have more power? Is there any hope that you see? Can you be positive?
Well, the hope, I was recently in Florida, and I was there when the amendment went down in Florida, and the amendment didn't pass in part because there were about 10 legislators had changed their votes or had been defeated and new people were put in who could have passed the amendment. It was not like all America wanted this defeated. It was a half dozen or a dozen legislators. And in Florida, when the amendment went down, there was a very strong network, and they wanted to do something. And what they did is they went out and recruited women to run for the state legislature. They recruited 60 women to run for the state house. Now, some of those were suicide missions. I mean, there's no question. Putting somebody up against Dempsey Barron was a suicide mission. But of those 60, 30 survived the primary and 20 got elected. And they doubled the numbers of the women in the legislators. And I really think the strategy has got to be sort of a flooding the ticket approach. I would also like to see a major effort developed to get women elected into judgeships. Attorneys in the room, for example, who oftentimes an elected judgeship is the way to a federal district or a higher level state appointed judgeship. And they're not that hard to win. They're not, it's a smaller number, none in Virginia. And it's usually a smaller number of people who vote. It would be interesting to organize on a national level or a state level to see how difficult it would be to win some of these judgeships, because you have a more qualified pool to draw from too. I mean, and a more natural pool as opposed to women that may start on the school boards and move up to city council and move up to state legislature who may or may not be a lawyer. I mean, I think it's an easy judge. But I really think it's going to be religion, politics, and sports that are going to be the hardest institutions to crack. We'll see.
Anything else? Yes, ma'am.
It seems to me, and I'd like to know from people who know more about it than I do, that there will be a greater approach to racial equality than sooner than sexual.
Well, I'd say if the question was a greater approach to or emphasis on racial equality than sexual equality. Well, what we know legally right now, and that's been our concern with Judge Bork, is that there is in fact a legal school of thought that says, no, the people who wrote the 14th Amendment not only had race in mind, and by the way, only had discrimination by government in mind, and therefore that's how the 14th Amendment should be applied. That is why Judge Bork somewhat shocked the committee yesterday by explaining that among the decisions he thought unconstitutional was the one that ended discrimination in the District of Columbia. He did say he wasn't planning to roll it back. He just didn't think it was constitutional. But he also said, and this was the subject of his dialogue with Senator DeConcini that I recommend people reading, that he really does think that sex discrimination can be rational. You see, you have to apply, his words were a rational basis. He finds no rational basis for racial discrimination, but there could be a rational basis, and it's his quotes, for sexual discrimination. And when asked why, he went back to the toilets. Right? He went back to citing the toilets, I should say. So in fact, what we have right now is a two-track, and there is a serious legal impediment. Because on the one hand, as you will remember during the ERA battle, people say, well, you don't really need the ERA, because of course it says every person in the Constitution.
Thank you for coming.
Well, thank you. I'm delighted. Thank you. Thank you for coming.
Thank you very much.
Oh, great.
It's my only copyright to you. Thanks for coming. No, I should have, I guess. If you're interested in some of this, leave it on.
No, I got it. I'll walk over.
With Pat last night and you guys tonight, you'll see us in about
Thank you.
15 years.
Thank you very much. I want you to know.